Perfect. Awesome. Welcome, everyone. Thank you all so much for joining today's presentation. My name is Ariel Green, and I'm the Caregiver Support and Education Specialist for Care Partners, and I'm joined by Jennifer from AARP, as well as Linda, and they will be just sharing some brief information about AARP. They're actually one of our education sponsors, and we're so grateful for our partnership with them, even just with this and beyond. So thank you, thank you, thank you for being here. And then shortly after, I will just kind of share a little bit of information about Care Partners and what we offer. And then we will dive into our presentation today, and that will be facilitated by Angela Odinsky. She is an elder law attorney. She has a lot of information to share with you to kick us off for this series. And so I'm very excited to have each of you all here today. Just a few housekeeping. If you have any questions, feel free to drop them in the chat. I will be monitoring them. Angela also is able to see the Q&A. So if she sees it, she can answer the question live. If not, then I will repeat the question and we can either answer it during the presentation or after the presentation. So feel free to use the Q&A. I did email the handouts out, so you should have them prior to the presentation. That it would have come out in the 2 emails I sent, one yesterday and one today. If you by chance did not receive it, I will send it out in a separate email along with the recording so that you can watch it again or share it with a friend. So I'm going to turn it over to Jennifer and Linda, and they are going to share with you a little bit more about AARP, and then we will move on with our presentation. So thank you all.
Perfect.
Linda, I just want to say a couple of things here. Linda's going to do our introduction for us. Thank you so much for being here, Linda, with us today. Ariel, thank you so much for your partnership with Care Partners, and we really appreciate all the work that you guys do in the community, and we're happy to sponsor this event. I'll hand it over to Linda, and she'll do the opening remarks on behalf of AARP. Thank you.
Thank you, Jennifer. Welcome, everyone, and thank you for joining us. I am Linda Cantu, a volunteer for AARP here in Houston. AARP is a nonprofit, nonpartisan member organization dedicated to providing information and resources that are important to people 50 plus and their families. AARP's social mission is to empower people to choose how they live as they age. And through educational offerings like our workshops and cooking demos, we can provide our members and friends with helpful information like our healthy cooking series, our Zumba classes, and with partners like MD Anderson. And if you're interested in learning more about the Houston offerings, please visit us at www.aarp.org/Houston. And we can be found on Facebook, YouTube, and well, it's now X as at AARP Texas. And for those of you that are not in the Houston area, visit aarp.org/near-you for information near you, including free events, resources, and volunteer opportunities. And remember, AARP is always looking for volunteers. And if you have any questions about AARP or you want to ask a question to our guest speakers, please use the chat area, as Ariel mentioned, and we will cover questions at the end of the call. And now I would like to introduce you back to Ariel Green, Caregiver Support and Education Specialist with Care Partners. Again, thanks a lot for joining us today.
Thank you, Linda. I'm so happy that you are here. And so I'm going to share my screen here, and apologies, it says May 9th. I thought that it was just a generic slide, but we'll just move forward. But I did want to share with you all a little bit more about Care Partners. So some of you all may be familiar with our services. We are here to support older adults and family caregivers along their caregiving journey. We are based in Houston. However, we don't have geographic restrictions when it comes to our caregiver consultation programs and our online programs, such as our online education and our online support groups. we have, in addition to education and our support groups, we have a gathering place, which is a 3.5 hour program designed for those that have dementia. And then we have another activity program that includes our Dementia Day Center, and that is located in Houston, Texas. And so if you are in need of any resources related to caregiver support, finding resources, understanding, what's going on in your caregiving journey, please feel free to reach out to us. This is our telephone number. Again, this is a 3-part series, so ideally, hopefully you will come each week and you'll be able to go walk away with some really valuable information. Please feel free, like I said, to reach out to us if you have any additional needs. We'll be happy to help you. So I'm going to turn it over. I'm going to stop sharing my screen, and I'm going to turn it over to Angela. And I believe, Angela, you should be able to share your screen as well. There was a question in the chat about, is this info just for Texas? Yes, it's kind of geared towards Texas. Angela can kind of provide a little bit more context, but some of this information can be applied in other places. But when we get down to talking about Medicaid, that's really where it's going to be very much state specific. So, Angela, did I answer that correctly?
Yes, that's
Okay.
true. So let's go ahead and get started. So my name is Angela Odinsky. I'm a certified elder law attorney. My base of operations is in Bel Air, Texas, just inside Houston. But I help people from all over the state, right? Most of my stuff is transactional. We talk. The education is good for anywhere, especially in the state of Texas. We're doing a 3-part series. The first of it is the essential estate planning documents. And what I'm talking about in terms of the importance of them, what they do and how they can be used, that I think translates a little bit better state to state. The specifics of what it means to make a will and how we determine different things, that's going to be very state specific. So if you're not in Texas and you're helping somebody who's not in Texas, I would refer you to, seek legal advice for the state that you're in, because estate planning and probate, all of these things are generally going to be state specific. And so if you're calling in from Louisiana or Oklahoma or Arkansas or someplace like that, then you're probably going to be better off receiving legal information for that state. Not everything translates from one state to another, right? Because we all have each state has its own regulatory system, its own way of doing things. But the first one is the essential estate planning documents. Next, we were going to talk about, planning for long-term care, and what that looks like, and how we pay for it, and the things that we can do to maybe try to get some things in place ahead of time so that we're not sort of scrambling. And then the last one I do is specifically on public benefits and how to qualify for public benefits. That one is Texas specific, because each state has its own Medicaid program with its own qualifications, its own requirements. And so you cannot translate anything I say in the third part of this series that does not translate to another state at all. So I think Ariel has it right. Some things will translate okay, some things just simply won't. And again, it's always best to get legal advice for the state that you're in. And since we're currently in Texas and everything we're talking about is in Texas, everything that I'm going to be saying today is very specifically geared towards, the legal landscape of Texas. All right. So to answering that question, again, my name is Angela Odinsky. I am a certified elder law attorney. And what that means is that I've had additional education, I've taken additional tests, and I have access to additional resources that helps me better advocate for my clients who have diminished capacity, who have dementia, who have special needs, and to help families navigate the legal complexities that come with aging and having sort of age-related illnesses. Today is very basic. We're just going over things that everybody should have. Estate planning starts when you turn 18. When you turn 18, you are an adult. And what that means is that nobody else can make decisions for you. And so at the age of 18, For those of you parents out there who have adults in college, they should have a power of attorney. They should have a medical power of attorney, right? Estate planning starts the moment you become an adult. You don't have to have built wealth to need some of these documents. They're really important from the get-go. And we'll talk a little bit about why that is. So primarily estate planning is about control. Control over your legacy, control over decisions, control over how your assets, how your finances, how decisions are made when you are awake, aware, alive, but unable to make those decisions, but also how your things are managed when you die, right? So that's estate planning sort of encompasses this entire area of planning. It's not just, you know, the word estate I find so problematic because people think of like, you know, big sprawling mansions on all these acres, and that's what an estate is. An estate is, do you have a bank account and a car? Do you own a house? You have an estate as far as we're concerned, right? And so you need to be able to make sure that there is somebody in charge of managing this estate. So if you own a house, have a savings account, you need an estate plan. It's not about tax planning. For the immediate future until January 1st, 2026, our estate tax exemption for an individual is $13.61 million. For a couple, that doubles. That's a whole lot. I'm not usually working with clients who have taxable estates from an estate tax perspective, right? That is a lot of money. Now that is going to sunset. It's going to go down. It's going to be somewhere between 6 and 7 million per individual, and then double for a couple, right? So there's all kinds of changes that can happen, which is another reason why even if you do have your estate plan all together, sometimes it's necessary to have it reviewed because changes in the law occur. So let's talk about reasons why people avoid estate planning, because nobody wants to do it, right? It's one of those things that's like, you need to get it done, but you just can't bring yourself to actually pull the trigger and do it because you did intimidated by the process. This is a huge one. People are like, oh, it's just too much. It's too much work. I'm too disorganized. I don't have all my stuff together. And the thought of having to go through the work it's going to take to put everything together is just, it's too intimidating. It's worth it. You just take a deep breath and you decide that you're going to do it. And I think one of my favorite phrases from my close friend, she always says, how do you eat an elephant? One bite at a time, right? And so that's what you have to do. You have to approach this as this is a long-term investment. It's a long-term project that you're going to do, and you're going to do it one thing at a time. Talk to your estate planning attorney. They can help you like sort it out into different pieces and walk you through the best way of doing it. They don't think their estate is big enough to plan for. I think we've covered that. The worst calls I get, the most heartbreaking calls I get are people who didn't have a will. They didn't set anything up. They had $5,000 in their bank account, and it's going to cost $2,500 to go at least to go through the process of trying to get it out, right? And so even if you don't have much, something needs to be done with that. And it doesn't have to be necessarily legal paperwork, just having beneficiary designations, pay on death designations, but it's being thoughtful about what you do have and being thoughtful about what happens to it if something happens to you. People think it's too time consuming or too expensive. Let me tell you, it's a lot less time consuming and a lot less expensive for you to do it now than for your heirs to do it later. If you don't have something in place, it's far more expensive for them and it's far more time consuming for them. If that's not a concern of yours, that's fine. But a lot of people don't necessarily want to leave their family members with a mess, right? And so there's simple ways that we can do it to kind of help alleviate the sort of stresses on the family. People don't want to talk to strangers about their family or their money, and they don't want to think about their mortality. I can't tell you how many people that I've had that are like, but if I make a will, I'm going to die. And I have to remind them, you're going to die whether you make a will or not. Having a will just makes it easier on your family for that inevitable moment. Okay. Planning documents everyone should have. And So for the most part, this is going to be true in multiple states. Now, there might be some specific documents here that are only that state of Texas has, and they might not be available in your state. But generally speaking, these are going to be very similar in different places. So you can have a will or a trust, right? Which is basically going to determine what happens to your stuff when you die, who's going to manage it. A durable power of attorney, which to my mind is the single most important document you can have while you're alive. Medical power of attorney to make medical decisions, HIPAA authorization, physician's directive, oftentimes called a living will. So it's not like a will where you give your stuff away. It's just what your wishes are under catastrophic health circumstances. Designation of guardian prior to need, and appointment of agent for disposition of remains. Now, these are two documents I am not certain if they exist in other states. I know they exist here, and they're really helpful in a lot of very specific circumstances, which I'm going to talk about. So the two elements of your estate plan, like just to like take the mystery out of it, it's about your stuff and your people. And that's it. Like it's that simple. It's about your people and your things. And how are your people going to manage your things? We don't have to be more complex than that. It doesn't have to be more complicated than that. How are your people going to manage your things? A will is an instruction for your people on what to do with your things. It is base terms, that's all it is. It's your intention. What is your intention for your stuff? Your estate, a lot of people, is usually going to consist of land, financial accounts, vehicle, things that may not have a beneficiary designation on it, like your IRA and your life insurance policy. Those have beneficiary designations, and so those are going to pass outside of your will to the people that you designate. Now, if you don't designate anybody on those accounts, then they go through your will, right? So it depends on that's another thing to be intentional about. Estate planning is about being intentional about how you set things up. Hold on, there's a Q&A. I'm going to open it real fast. What's a HIPAA authorization? We'll get to that. We'll get to all of them. So important questions to have while you're creating a will. What do you own? And again, be thoughtful about this, because the bane of my existence is someone who comes to me and they're like, oh, we have everything set up. We've got beneficiary designations. Everything's where it needs to be. We're all good. And then come to find out, actually, they had inherited mineral rights from a grandfather 15 years ago that nothing ever happened with, and they never put anywhere. And so now we're trying to figure out what to do with those mineral rights. Right. So when you're talking to your estate planning attorney about your plan, it's really important that you tell them everything, even the stuff that you forget about, because there's no royalties coming off of those mineral rights. They're not leased or producing. You just ended up inheriting this thing that you don't know what to do with, right? It's still relevant. We still should do something with it. We still should have some kind of plan in place for that as well. Nothing's irrelevant, right? Everything should have a plan for what's going to happen with it. So knowing what you own is really important. Knowing whether anybody else owns it with you is really important. So that mineral right I was talking about, do you split it with 50 cousins? That's important. Like, we need to know who all owns that with you. I don't need all their names. I just need to know that there are a bunch of other owners, right? Do you have community and separate property? Did you inherit things after you got married? Did you keep that inheritance separate? That might be separate property, right? So if you didn't commingle it, and then you can dispose of that property however you want to. Community property, you can dispose of your half however you want to, but the other half does not get disposed of however you want. That belongs to your spouse, right? So how do you own everything, and who do you own it with? And if a spouse has passed, did you do the things that needed to be done with their estate to transfer their interest to the people it needs to go to? I think one of the most important parts of this talk that usually happens is informing people that just because you own your house with your spouse in Texas does not mean when you die, your spouse automatically gains ownership of that house. Most of our community-owned property is not owned with a right of survivorship unless you have taken steps to make that the case. So what happens is you and your spouse buy a house together, you own 50%, your spouse owns 50%. And when your spouse dies, you own 50% and your spouse's estate owns 50%. And so we have to do something to transfer that spouse's 50% to you to make sure that now you are the full owner. This becomes really important when we're dealing with things like homeowners insurance for hurricanes, right? Because the last thing you want is to get a check for half the amount that you need in your name and the other half in the estate of your late spouse, where there has been no probate or anything else. And so now we have to kind of scramble to get that taken care of. And so it's very important to understand home ownership, how you own it, who you own it with, and what we need to do to make sure that the estate's taken care of. Then where do you want your property to go? Who do you want it to go to? There's no requirement that it go to anyone specifically, right? So in Texas, you can give it all away to charity. Your kids do not, like, there's no entitlement for your property. It's your money. You made it. You did the thing. You can do whatever you want to with it. When you die, there's no requirement that it goes to anyone specific. And then who is your executor? So the executor is the person who's going to call the attorney, set everything up for probate, pay all the bills, distribute out to the beneficiaries. This is the person that you trust to cross the T's and dot the I's, right? That's the one who's going to be in charge of, like, managing your estate. So those are kinds of things that you need to know or think about before you go into your estate planning attorney's office. All right. So there's a bunch of different ways that you can give your things to your people upon your death. So we just talked about a will, right, which has to go through probate, which means that it has to go to court and be verified as a will, and then have the executor named and, like, go through this process. But then there are probate avoidance, right? So probate avoidance are beneficiary designations. So when you do your retirement account, your IRA, when you have your life insurance and you set a beneficiary on it, those avoid probate. So your will has nothing to do with those. Those get passed completely outside of your will based on the names that you have listed in beneficiaries. Your will does not override it. So if you put in your will, you want your retirement account to go to Sally, but you've designated Ben as your beneficiary, Ben gets it, right? Because it passes by contract, the will does not control it. So it's really important to make sure that your beneficiary designations and your will or your estate plan are harmonized so that everything's going to the place that you want it to go. You can pass things via a will or a trust. So a trust often will distribute in the same basic ways that a will are. Now, there are differences between wills and trusts, which I'm not necessarily going to get into on this because there's a whole lot to cover. But it's worth talking to somebody about the differences. And then finally, if you don't have anything at all, it passes via state law. There is a list of beneficiaries and who gets what in Texas statute, and it can be, I don't know. I was talking to somebody recently about an heirship with somebody who didn't have children and didn't have any siblings left, and there were no nieces and nephews. And so we went up to their parents' level. Their parents didn't have any siblings. There were no cousins. So now we're up to the grandparent level. It's like the grandparents had siblings. And so now we're going all the way down to whoever the grandparents' people are, right? Because and so on until everyone is found. And so if you don't say who it's going to go to, it could go to perfect strangers. And that's just what happens. So we talked a little bit about how things go to people outside of your will, right? Beneficiary designation, right of survivorship. The right of survivorship automatically passes to the other person or other people on the account. And so a lot of times, so when it comes to married couples, I was talking about how there's no right of survivorship on the house. There usually is a right of survivorship on the checking account. So if you're a couple and you own a checking account together and you own the cash in that account, then when one of you dies, the other one generally is going to seamlessly be able to continue management of that account. I always advise my clients to call the bank and make sure there's a right of survivorship, because I have definitely helped clients in probate where there wasn't. And so the account got frozen until we could figure it all out. But generally speaking, 99% of the time, when you open an account with your spouse, it's going to have a right of survivorship, so that on the death of the first spouse, the second spouse just seamlessly manages it. Now, sometimes adult children will be named as owners on those accounts as well. It's also a really good idea to check to see if there's a beneficiary, if there's a right of survivorship on that, because if so, it means that the adult child who's on that account just gets the money. And it wouldn't go via the will, and it wouldn't pass to any other children or siblings or anybody else. And so, and even if the child who's on the bank account wants to do the right thing and is willing to split everything with his or her siblings, there could still be like small administrative issues. Like if it's over a certain amount, they'd have to file gift tax returns because it's their money now they're gifting to their siblings, and there's all these little things that people don't realize when you put these accounts together and you think about doing everything and you're like, oh, this is just going to be convenient right now. And it is, but there might be other consequences that you hadn't thought of and that no one brought up. And so that's one of the reasons why you engage in estate planning with an attorney, is to kind of go over all of these things, make sure everything is in place exactly the way you want it to be. And then, of course, beneficiary designations will automatically pass. So when someone passes, you contact the insurance company, there's a beneficiary designation, they send out a packet, you fill it out, you send it to them, they send you a check, we're done. That's often how it works. Well, really, you send them a packet, they tell you they didn't receive it. You send them a packet again, they tell you they still didn't receive it. You send them the packet again, and eventually they send you a check, and then we're done. Sorry, that's my jaded opinion. Okay, so let's talk about a valid will in Texas. So in order to create a valid will in Texas, you have to have testamentary capacity, which is a fairly low bar. So I want to be very, very clear here. Just because a person may have a diagnosis of dementia or some kind of cognitive decline, that does not mean that they automatically do not have capacity to create a will. So if your loved one that you're caring for has a diagnosis of dementia and doesn't have a will, you don't necessarily have to throw up your hands and say, oh my God, this is going to be such a mess later on. There might be a way. If your loved one still has good days, if they still know who they are, they know who their kids are, they have an idea of what they own, and they know that making a will means giving their stuff to their people when they die, and they have all of those thoughts in their head while they're signing the will, then they might still be able to sign a will. It's worth having the conversation. Because if you can get that done, even if somebody has been diagnosed, then it's worth having that done so that we don't have to worry about dealing with going through heirship and Texas state law for who gets what, right? Because it's a lot more expensive. When you don't have a will, you end up paying 2 lawyers, because you have one lawyer who is going to be representing the person bringing the heirship, and then you have another lawyer who represents unknown heirs. And so it's important to at least have that conversation to see if somebody has capacity. So I have a question. It says, is a will drawn up for me by an attorney in New York State when I lived there valid in Texas where I live now? So that is, generally speaking, if a will was created per all of the requirements of the state where you were at the time, then it will be honored in Texas. I have probated wills from Illinois, I've probated wills from California, I've probated wills from New Jersey. As long as they were legally created under the laws of that state, then it can be probated here. The question is, does it still do what you wanted it to do, right? And so if everything is still the way that you want it, then then it is still, then it's good, but be very, very careful because Texas is a community property state. New Jersey was not a community property state, which means that the way that the distribution in the will was different from how we would have done it here. And we ended up having to, my client, the spouse, ended up having to pay the daughter of the deceased spouse for half of the house. And so like there's little landmines that might be in some documents. While it will be honored in Texas, there might be things that could cause issues later on that are worth looking at. Should a will be filed with the county records? No, the county doesn't care. I mean, you can give it to the county for safekeeping, but if nobody knows it's there, then it doesn't help. You should take your will and keep it safe. Now, after a person has died, a will has to be filed in the county records, right? Like by Texas law, that's required. But while you're alive, you keep it and you keep it safe. How would I address the executor paying for expenses, the house note, etc.? That's part and parcel of it. If the executor pays, then they get for estate expenses, then they get reimbursed. That's something you talk to your probate attorney about. So how do you address the executor paying for expenses, house note, etc., in the estate if one adult child doesn't have a right of survivorship? I don't understand that question. I don't know what the adult child having a right of survivorship has to do with an executor paying expenses. It would come out of the estate, right? Like that's how that works. I mean, that would be something that you would talk to your probate attorney about at that point. So it's often the case where somebody who has a who is the executor of a estate and there's still like a note or something on the house, we go through probate and then pay it through the estate. Sometimes the executor can front the money, sometimes they can't, but there are rules in place so that there's not going to be as long as you have like there's time, right? So there are rules in place to make sure that there's no foreclosure while we're in the middle of a probate process. We just have to get the process started, get an executor named, and then we can take care of things. So it's not required that an adult child be a right of survivorship to manage those things. It can be helpful. Again, it can also cause additional issues, but that's a question for your attorney, right? So that's, in some cases, that might be the right answer, but it's not the right answer for everyone in every case, because all of these things are completely, it's going to be dependent upon your personal situation. So the next question is, how long is probate? Well, it depends on where you're at, right? So in Harris County, we can usually get it done in a couple of months. In other places, it takes a little bit longer. It really does depend on where you're at, whose court you're in, and how long their docket is. There's no guarantee. And what the estate looks like. I mean, some estates take a long time because there's a lot of different kinds of assets that we have to deal with. So again, this is a very personal sort of, not personal, but very individual kind of thing. There's no one size fits all, and there's no one answer to any of these questions. It's going to depend on the circumstances of the time. The will cannot have been tampered with, which means that a will, you can't have written on it. Okay, people are asking me some individual questions about their own personal wills. I'm not giving legal advice. And so I'm not going to be answering personal questions about your own individual wills or your own individual situations. And so there is a question here. If you live and die in Texas and your POA is from out of state, can the POA get access to the dead person's checking account? No. A power of attorney dies with the principal. No power of attorney is good after someone dies. So that's true across the board. You can't be an agent for a person who's dead. Only the executor can have access to checking accounts at that point.
Okay, Susie, you raised your hand. If you want to unmute yourself, if it's a personal question, I will defer to what Angela said. You can reach out to an elder law attorney individually, but
Mm.
I did want to give you the opportunity to ask your question live if you're not able to type it in the chat. So Susie,
Yes, can you hear me?
yes.
Okay, good. My question really is, when is a will necessary and when can you use a trust?
So so it depends on what your individual circumstances are. For some people, a trust makes a lot of sense. For other people, a trust does not make sense. Trust is about burden shifting. Trusts versus wills are about, like, they have different requirements, they do different things. A trust, all of the work is done up front. You put everything together, your trustee then manages it, and then when you die, it avoids probate, and then everything gets distributed out to your beneficiaries by your trustee. All of the work's done up front. It's more expensive because there's more work up front. A will, all of the work is done on the back end. You make your will, you sign it, and then your executor collects all the assets, pays all the debts, and then distributes out to the individuals, to your beneficiaries. So as far as when is a will worthwhile versus when is a trust worthwhile, it depends on your circumstances, right? Like, I sometimes, when I have a consultation with somebody and I'm looking over their situation, sometimes I'm like, you know what, a will sounds fine for you. We don't need a trust. These are your circumstances. This is the kind of assets you have. And I think a will is going to do everything that you want it to do and not be too burdensome on your family. And then for other people, I look over everything and I'm like, you know what, I think a trust is going to be more in your best interest. For people who are trying to manage assets, for somebody with dementia or people who are managing assets, if there's a diagnosis early on, then I like to talk about trust from a management perspective. But again, there's no hard or fast rule. It depends on the goals of the individual person as to which one is going to be in your best interest, and do what you want it to do. I do both, and it depends. For blended families, trusts can be a little bit more protective. If there's a concern of divorce for an adult child, then a trust might be a good idea. If you have 2 adult children, you're leaving everything to outright and there's no complications, then a will is probably going to be in your best interest. It's just, it really does depend on your circumstances. I don't believe in one size fits all estate planning. I don't believe in one and done estate planning. Every individual situation is different, and every individual's situation is going to change over time. And so you're going to have to review your documents over time to determine whether or not they're still doing for you what you wanted them to do. So this whole the will can't be tampered with in Texas is really important. If you don't like your executor that you named 15 years ago anymore, you cannot mark it through, handwrite a new name in and initial it and expect that to be valid. It's not. If you don't like a provision anymore, you can't retype it and then just slide it in there. That's not how this works. Wills are not contracts. You don't change them and then initial them and expect them to be honored. I did have a client one time that just used an old will with an ex-wife's name and he just whited out the ex-wife's name. You cannot do that. That's not how this works. If you need a new will, you need to go and get a new will. If you need to change your will, you need to go and get a new will, because it's taken very seriously when you bring a will to court as to whether or not it's valid. Those kinds of changes are not considered valid. Okay, there's 2 ways to write a valid will in Texas. It can be typed, signed, attested by witnesses, self-proved, beautiful. We go in, we go out, probate's a breeze. It can also be entirely handwritten without any witnesses and no notary. But handwriting witnesses are required to testify to the will. I don't know when the last time any of you wrote a letter was, but let me tell you, finding handwriting witnesses who can credibly testify to someone's handwriting is getting harder and harder and harder. I do not recommend handwriting a will. I don't recommend making your own will because a lot of people don't know what they don't know, right? And there are things that you can do, complications that you can create yourself without knowing for your family when you do it yourself. So why shouldn't I just create my own will? It's easy to create problems and time and money. So issues that have arisen, minors weren't able to access their inheritance because it wasn't put in the right spot with the right person overseeing it. You can easily make an heir lose government benefits. Really, really well-meaning family members love to leave things to adults with disabilities. Well, that adult with disability is on SSI and Medicaid benefits, and then your very generous gift has just kicked them off of benefits. If you want to leave them a gift like that, we can absolutely do that, but we have to do it correctly. We have to do it using the right kinds of vehicles. They can still get the money, but it doesn't have to kick them off benefits if you do it right. And so if you intend to leave money to somebody who either has special needs and has government benefits or may need government benefits in the future, talk to your estate planning attorney about that and about what you want to do and how, so that they can set it up for you in a way that doesn't jeopardize someone's benefits. That happens so often, and it's so sad. People try giving away things that doesn't technically belong to them, especially in spousal situations where you have one spouse who's doing planning on their own without the other spouse, which is perfectly fine. Different people have different arrangements, but they don't realize that without a signed marital property agreement, everything they've made together since the date of their marriage is community property. So no, you can't just say, well, I've kept this account separate, so this account is my separate property and I'm going to leave this account to my kids. That's not quite, again, how that works, because that account actually is community property. And so we have to adjust for that unless you have already done the right legal work to make it separate property. Just having your name on a separate account doesn't make it separate property. And then, yeah, of course, no living witnesses to testify to handwriting. That is so, so difficult. And getting more and more difficult. Also because they're not teaching handwriting in schools anymore. So like your grandkids couldn't read it anyway. That's a problem. All right, more questions. Do DIY wills and trusts have to be notarized? I'm not about to give legal advice on the validity of DIY wills and trusts. There's different requirements again for different things. Wills, yeah, the wills, if they're typed and witnessed, they don't have to be notarized. Trusts don't necessarily have to be notarized, but again, I cannot, it means they're not self-proved. Like DIY, you can create so many issues that you have no idea that you've created. So I just wouldn't, I have had somebody like do a will and then just sign it and have it notarized all by itself. And that wasn't valid because they didn't do all the rest of the requirements that needed to be done, right? Because they didn't know any better. So just, you have to be very, very careful. And I cannot recommend doing them. Should your will include a trust? Sometimes you can create a trust with a will. So you can have standalone trusts or you can have trust inside of wills, depending on what you need. And if you have a spouse with dementia and special needs, maybe creating a trust for that spouse so that they can qualify for public benefits is a good idea. That's a thing to talk to your attorney about. I'm not answering any questions about that right this second, because it's a very specialized kind of practice, right? Are you leaving property to a minor? It should probably go into a trust for that minor's benefit. Are you leaving property to a person with disability or who need government benefits? You leave it to them in a trust. It doesn't jeopardize their benefits. Do you have specific wishes beyond just who gets it? If you want to attach strings, strings are attached with a trust. And do you want to leave funds to support a pet? Right? So pet trusts, if you want to like leave somebody around to name somebody to make sure that your pet's taken care of, and a little bit of money to do that, we can do that. I love making pet trusts. It makes me feel good. So the probate process is all about wrapping up the estate. It's about taking the will to the court, having the judge say, yes, this is a valid will. Yes, you are qualified and not disqualified by law to serve as the executor. Go forth and do what you have to do. And that's what the will is. That's what probate is, basically. it can be time consuming and it can be long and drawn out, but it doesn't, if it's uncontested, it's just crossing the T's and dotting the I's. It's just administrative. You just have to get through it. You just do the one thing and then you do the next thing and you do the next thing. And it doesn't have to be so horribly painful. It does confirm ownership and it can prevent unscrupulous credit scams. I have definitely seen people get billed for things that right. And so in probate, we have ways of managing those to make sure that all creditor claims are valid creditor claims. And so that's what we do in probate. So I have another question. How can real property be given away? Jewelry, car, etc. So personal property. Adding a list to will. Oh, so what happens to your personal property? What happens to your things? So you can do something called a personal property memorandum, which is attached to your will. It's not binding by law, but it tells your executor where you wanted your stuff to go, right? So, and that's something that you can put in your will itself. Like you can make a specific thing that says, if I have a memorandum, I'm asking my executor to acknowledge that memorandum and say, this is where it's going to go. You don't have to name everything. That's a lot of people are intimidated by the process because they feel like they have to give away everything in the will, and you don't. You can do these personal property memorandums to help give away specific stuff. And again, real property does not automatically have a right of survivorship on it. So just because you own it with your spouse and you bought it together as a married couple does not mean there's a right of survivorship on it. And so you might still have to, like, you still have to transfer it after death. Okay. Powers of attorney. I've only got like 10 minutes left. So hold your questions until the end so I can get through these slides. Chooses someone to make financial decisions for you, and a well-drafted power of attorney can potentially alleviate the need for a guardianship, which we always want to do. A power of attorney is more important to me than any other document that you have, because it is who and how manages your money and manages things for you when you are incapacitated and unable to manage them for yourself. Again, this is one of those things, just because a person has a diagnosis of dementia does not mean that they are automatically precluded from signing one. It depends on their understanding of the document and what it does. And so it's worth contacting, especially a certified elder law attorney who deals with people with dementia, to at least have an evaluation to see if somebody can sign it. Because if you don't have a power of attorney, it can be very challenging to manage things. Medical power of attorneys, who's going to make medical decisions for you. If you don't have this document, there is a statutory list of people who can make decisions for you, unlike the durable power of attorney, which does not. And so if you don't have this, then at least there is something as a backup. But I do highly recommend that everyone have a medical power of attorney. A HIPAA authorization is your eyes and ears for medical decisions. It's not somebody that can make decisions for you. It's someone who can gather information. So it's a health privacy it's a health privacy act, basically. And so you have to sign a form giving people permission to talk to your doctors. And so if you want your adult children to be able to talk to your doctors on your behalf about your medical condition, your prescription drugs or whatever, then the doctor has to have authority to talk to them. And that's what this document does, is it gives authority for that. That was a question earlier on in the day as far as what's a HIPAA authorization. It is authorization to have individuals receive information that's otherwise private about your medical condition. A designation of guardianship prior to need is a document that we have and we hope we never pull out of the drawer. It is a document that says, if by some force of bad luck, it is determined that I need a guardian because I cannot protect myself from financial exploitation or other abuse, then here's a list of people that I want to be my guardian. And here's a list of people that I do not want to be my guardian, right? You don't have to exclude anybody if there's no one you want to exclude, but just naming some people at least gives the court something to go on as far as who you trust to manage your affairs if it is deemed that you are not going to be able to manage them. If you don't have this document, it's okay. The judge will determine based on who brings the application, but having this document again is just one more aspect of control. When you don't have control over anything else anymore, who is going to be, you can still have a say in who is going to help you manage your affairs in your day-to-day life. The Living Will Physicians Directive is the document that says, you know, what if you are in a catastrophic health crisis and you are not expected to live longer than 6 months, you can't make your wishes known, you can choose keep me comfortable and let me die gently, or do everything in your power to keep me alive. The other scenario is if you are incurable, meaning the doctors have done everything they possibly can and you're never going to get better. It's the same options. Keep me comfortable and let me die, or keep me alive as long as possible. This is the most personal of all the documents. And it just kind of really helps to, it really helps your family to advocate for you because they know what your wishes are. So the question here, can the power of attorney serve as a HIPAA designation? You can name the same people on all the documents, right? Now, an agent under a power of attorney is not automatically going to be able to receive HIPAA authorization. You have to have a separate document designating that. But a person can designate the same people on everything, which is what usually happens in family circumstances. Spouse is named as the first agent, followed by the adult child number 1, followed by adult child number 2, followed by adult child number 3, right? That is usually how it works, and that's on all of them. It just depends on who can do the job the best. Who's the most financially capable, who's the most medically capable, who's the person that is most capable of carrying out your wishes. That's the most important when it comes to medical. Who's the person who's going to do what you told them to? And who knows you and knows what you want. That's the important one. Why a designation of guardianship prior to need versus a power of attorney? It's not versus, it's both. A power of attorney can only work so far. The agent under a power of attorney cannot veto the principal, meaning that if your principal says, I want to go buy a fleet of boats, and you say, I'm not doing that because as an agent, that's a bad idea. But then the principal goes out and buys the fleet of boats, you can't stop them from doing that because an agent can't veto the wishes of the principal, no matter what their diagnosis is. But a guardian can. And so if it is a situation where a person is, it's an issue of self-neglect, self-financial neglect, self-personal neglect, etc., then their rights are stripped, they're no longer able to do anything, and then a guardian is placed over them to make all of their decisions. They are very, very different documents, and they are used very, very differently. We have the power of attorney. We make it broad and expansive so that the agent can do whatever needs to be done, and we hope that it's enough. If the agent under the power of attorney starts abusing their power, sometimes we have to seek a guardianship to protect the principal from the agent. I've done that before in a couple of cases. So, you know, I mean, the guardianship is a different, the guardianship prior to need is a different document. It's not an either or situation. It's a you have both situation. And then finally, it's the appointment of agent for disposition of remains, which is who gets to plan and pay for your funeral. Funeral homes love this document because it gives them one person to talk to. Nobody's fighting. Nobody, like there's no other opinions get to enter into this. The person who's named is the person who gets to do it. Again, this is really good in blended families. When you have, you know, I get calls from adult daughters saying, you know, stepmom wants to have dad buried in her family plot in Ohio, but he wanted to be buried here in Texas. And so, you know, how do I stop this from happening? And my first question is always, is there a designation, appointment of agent for disposition of remains? And when the answer is yes, I ask who the person is. And if it's them, then they have the authority. And if it's stepmom, then stepmom has the authority, right? And so that's how these kind of come into play. That's how we end up like using these documents. Oftentimes there's no fighting, it's fine, but it just tells the funeral home who's in charge, right? I love doing these documents. I'm a big fan of pre-need funeral contracts, just pre-planning it and pre-paying it. I still like this document for the little incidentals, but it at least, it gives everybody something to go on as far as what your wishes are. So what happens when you don't plan, when you don't go talk to somebody and at least get an idea of what to do or what it might take? You lose your ability to make decisions. right? Regarding your property, your legacy. Probate can be longer and more expensive if we have to go through an heirship or if things weren't done correctly. And so I had a DIY will one time where the person didn't leave anything to anybody. They set up a trust and said, you know, if my estate is a taxable estate, then I want to set up this trust. Well, when they died, they didn't actually have a taxable estate. And that was it. So they did all this stuff. They created it themselves, but they didn't understand what they were doing. And so basically they had a document that was completely worthless as far as distributing their assets. It's just, it's worth the cost of the consultation for someone to walk you through what you might need. Because it can be so expensive and time consuming if you do it wrong. There can be pitfalls you never knew about that planning would highlight, like the idea of a right of survivorship for an adult child. I had, again, everything, all of this comes from experience, right? Like nothing I'm saying isn't from an actual case that I dealt with. So I had an adult child who was right of survivorship on an account. There was about $400,000 in the account. He was so good. He loved his siblings. He wanted to he split everything with his siblings. It was not, that was her intent. He wanted to make sure his mom's intent was taken out. That's fine. But now we had to file all these gift tax returns because now he is gifting his siblings like $100,000 each, which is more than the $17,000 allowed without having to file a gift tax return. Now he didn't have to pay any taxes on it, but he did have to file it. He'd have to go to his accountant and deal with all of these extra administrative costs. And so it's just like, there's all of these little things that people don't realize that could affect their loved ones later on. And so you talk to somebody, you figure all of that out, and then everyone can make a decision for themselves as to whether or not it's important. But don't be caught unawares because you didn't want to have the conversation, right? It's all about just having the conversation. That's what's so important. And your property can be distributed per state statute if you don't get everything done. So that is, I'll go ahead and stop sharing, and then I will continue answering questions for a few more moments. If an elderly person has moderate to severe dementia and there is a POA, but no, then there's a financial power of attorney, but no medical power of attorney, does one adult child have more authority than another? No. The statute says the majority of reasonably available adult children. So there's no priority given like for birth order or anything. So no one child has greater authority or less authority than another, as far as that goes, unless there's a medical power of attorney in place. And if y'all want to fight about it, then you're going to end up in court. So everyone really just needs to get on the same page. That's the best advice I can give. That really is the best advice I can give. Talk about it. Know your family, like know who your people are, and have the same, like, try to come up with a solution that's not fighting about it. It's so hard. It's so hard on families to do that. What about social media accounts, virtual accounts by the deceased? What pitfalls to be concerned with? So we just recently got something in the statute that says that an executor can handle digital assets. I also try to write into my powers of attorney and into my wills that the executor or the agent of the power of attorney can manage digital assets to deal with those kinds of things. But it's a very new and interesting sort of area to deal with digital assets. So, you know, oftentimes we're dealing with going through different departments. I will say that both Android and Apple, you have to look up how to do it. I cannot tell you. I am not a tech person, but I have seen it done. You can actually, if you have Apple devices, you can go through and name your person to manage your stuff if you are incapacitated or after you die. And so that way you're not relying on these documents, you're relying on their stuff, which third-party companies really love their stuff better anyway. And so I don't remember how to do it, but I had somebody walk me through it one time, both with Apple and with Google. And that kind of helped manage the Apple devices. It helped manage the Google devices as far as like naming a person. So there are technological solutions to some of these things as well. All right. I don't know that I have any other questions. I did have a comment. Great advice not to fight, but you can't reason with an unreasonable person. I understand. I do. And there are many, many attorneys who can help you, because that's, you know, when you end up in litigation, you have to fight it out. That's just heartbreaking to me. Our subscription stops when death occurs. You have to tell people, right? I mean, you have to inform them, but they should stop the moment you call them and say this person's dead. Then that subscription should stop. Like you have to cancel it, but you have to affirmatively do it. Like there's nothing happens automatically. People aren't just informed that someone has died. People aren't just informed that things are occurring. Like someone has to reach out and go through the process of taking care of it. But yeah, you will cancel the subscription when somebody has died. All right.
Awesome. Thank you, Angela. So we will be sending out the recording today or sometime tomorrow, but please also join us next week for, is it Aging in Place? Is that the
Next week is aging in place and sort of long-term pre-planning, how it all looks. We will do that. Somebody's asking for my phone number. I will happily give that. It's 713-344-0730. That's my office number. And feel free to call me. It's also on the slides, so you can see it there as well. I look forward to having everybody join us next week for the long-term care pre-planning, and then stick around for the third one, which is usually the bigger draw, because we actually talk about benefits and how to qualify and what it looks like. And it can be very informative. That one's very informative. So, all right, everybody, thank you so much. Thank you, Ariel. Thank you, Linda. Thank you, Jennifer. It was wonderful, and I will see y'all next week.
Awesome. See y'all next week. Thank you so much. Y'all have a great evening or afternoon. Thank you.
Bye-bye.
Bye.
Bye.